Besides being an Arizona estate planning attorney, I'm also an attorney who forms LLCs for people. We formed over 9,200 Arizona LLCs. And one of the issues that we find that is very important for business owners when there are multiple owners is they need to plan for what might happen if one of the owners were to die. Because we all know that it's inevitable, but what happens is people will form a business, they'll start operating, and then suddenly one of the people dies, and that can cause extreme problems for everybody concerned. Not problems just for the family of the deceased person, but problems for the other business owners. Because now it may be that the interest of the deceased person is inherited by somebody who the deceased person would not want to inherit. Arizona law provides that if a person dies without a will or a trust, then there's a state law that determines who inherits the assets of the deceased person. So we encourage our business clients to have an estate plan, but unfortunately, too many people like to procrastinate. So it's common for a business owner to die without a will or a trust. And that means that the interest in the company and the person's other assets are going to be going to the person that the Arizona law provides inherits the assets, which for a married person, the assets go to the spouse if all of the children are children of the man and wife. But if the children are from a different marriage, then half of the assets of the decedent go to the children of the other marriage, and the other half of the assets go to the spouse. Now, if a person dies and they don't have a wife, then all their assets are inherited equally by their children. If they don't have children, then all their assets are inherited by their parents equally. But if both parents are deceased, then the decedent's assets are inherited by the decedent's siblings.